All right, everyone. Welcome to Chapter 6 of our MDC Criminal Law course, where the chapter that we're going to be talking about today is basically a large umbrella chapter where we're going to discuss all of the other crimes against people that are not related to homicide, right? If you remember last week, we talked about how homicide was divided into, first off, excusable and justifiable homicides, right? Versus criminal homicide. And within criminal homicide, we divided into murder and manslaughter. And we talked about how there's degrees to that and all that. Well, all that homicide topic, or even more specifically, the criminal homicide topic, is one example, or is only one type of crime against the person. Today, we're going to talk about pretty much almost all of them, all the others, right? All the other significant ones. So the textbook starts off with wanting to describe the first one, assault. Now, let's address assault because assault is a bit tricky. Technically, there are two separate crimes. There is the crime of assault, and there is the crime of battery. Now, assault is defined as the unlawful attempt or threat to inflict harm, immediate harm, or death. That is assault. So assault is a threat. If we are going by the most technically correct definition of assault, assault is a threat to hurt somebody immediately, or to touch them in a way that could potentially kill them. So either you're threatening to hurt them or threatening to harm them in a very serious manner. That is assault. Battery, on the other hand, refers to any unauthorized, harmful, or offensive touching of another. Okay? So, battery is when essentially the threat of assault is carried out. Battery, however, does not have to only be hurtful or harmful touching. It can be an offensive touching. So it doesn't necessarily have to be something that leaves a physical scar, but it can be somebody groping another human being sexually without permission. That would be an example of battery. Okay. Now, even though assault and battery, we can very clearly separate them as two separate crimes. And in fact, our legal system does so. When we talk about this informally, many times people combine the terms assault and battery into simply just the phrase assault. So what you hear many times in movies and TV shows is, oh, he assaulted me or she assaulted me. And what they're really trying to say is that person battered me, right? Because our way of speaking, we've lazily shrunk two different crimes and many times just combined them into this crime called assault. When in reality, our legal system recognizes that they are two separate crimes: assault, the threat to hurt somebody immediately, and battery, which is the actual touching of somebody in an offensive or harmful manner. So sometimes you may see people combine these terms into assault. Don't get confused by that. It's not correct, but it happens a lot. And it shouldn't, in my opinion, it shouldn't happen, but it does. So, understand that in order for assault to exist, the threat must be immediate, for immediate harm. So an assault is not somebody who threatens to hurt you in 6 months. That is not assault. The threat that's mentioned within assault must be very immediate, must be very um, imminent, is another word for it. Okay. So that is a requirement for assault to take place in most state legal systems, in most state jurisdictions. Now, with battery, there's something else that I want to discuss, which is not every unauthorized touching of another person is offensive. Okay. If you're in a subway station and you're in a train and people are, trying to walk through and somebody touches you on the shoulder, trying to make space, well, they didn't have permission to touch you. But because you are in a public place where it's expected for crowds to be tight, it's not a crime for somebody to touch you, even if it's an accident and it's somewhere that you didn't want to be touched, as long as obviously it's an accident, right? It's common sense prevails. You're not going to be able to say that somebody battered you because they touched your arm without your permission in a tight space under those circumstances. Because again, the expectation is that those tight spaces lend themselves to people, not pushing with aggression, but jostling for position and trying to move and make space for one another, and that's just nature. So that wouldn't count as battery. All right. But battery could be something like spitting at another person. Battery can involve, obviously slapping, depending on the circumstances, slapping on another person. Those are examples of battery, right? Even if there is no physical harm, the unauthorized touch of people under those circumstances counts as battery. Now, I'm going to mention something the book doesn't talk about, right? For battery to take place, the touching had to have been unauthorized. So whether it was offensive or harmful, the person did not have consent to touch you. Whether the person physically hurt you or whether the person touched you in an inappropriate manner, it was without permission. What about boxing or MMA or UFC fighters? Well, those are not unauthorized, right? Both fighters agree to the physical contact. So therefore, even though there is potentially harmful touching, both sides consented to it, therefore, not battery. Just wanted to make sure that we were clear on that. Now, our legal system does separate assault, or let me phrase it differently. Assault that's done with a weapon compared to assault that's done without a weapon. Assault that's done without a weapon most of the times are pretty much going to be considered simple assault, right? So if you threaten somebody with a weapon, we're going to most of the time label it as a simple assault. If you batter somebody with your fists, depending on how much harm there could have been, it might be also a simple battery. The law does distinguish those instances of assault and battery with what we call aggravated. Now, here's a tip, because you're going to see this word aggravated, not just with assault and battery, but also in other instances of this chapter within a criminal law context. Whenever you hear the word aggravated, I want you to think of a murder weapon, or not necessarily a murder weapon because it didn't have to result in a murder, but a weapon. So a gun, a knife, a crowbar, something of that nature. All right. So aggravated assault is, well, you threatened to hurt somebody and you had a gun pointing at them or a knife pointing at them, right? Aggravated battery, well, you had, a crowbar. You beat somebody up with a crowbar. Or you stabbed somebody with a knife, right? Those would be instances, respectively, of aggravated assault when it's the threat, and aggravated battery when you actually hurt the person with your weapon. And aggravated assault and aggravated battery are going to be punished more severely than simple assault or simple battery. All right. So I just wanted to make sure that we understood assault, battery, simple assault, simple battery, aggravated assault, aggravated battery. Again, remember that in order for aggravated to take place, it's with a weapon. If it's simple, it's without a weapon. That's a pretty easy way of remembering. All right. Some states have created this concept of reckless assault. Reckless assault, the textbook doesn't really give a nice definition that I like for it. Yeah, it's not here. But reckless assault is assault that takes place with reckless behavior in which through your assault, you actually place the person at real risk, very real risk of severe bodily injury or death. Kind of tricky to see how you separate reckless assault from aggravated assault. I guess you could put somebody's life at real risk for real injury or real death potentially without needing a weapon. But I don't know. It's a little bit tricky to separate reckless assault from simple assault. I won't test you on reckless assault. I just don't like the concept, but I did want to introduce you to it as a term. There is also another crime that is called mayhem, and it's also within this tree or this relationship, or it's also related, let's say, to assault and battery. Mayhem is when let's look at the complete definition of the textbook. I don't want to use my own words. Mayhem is a common law offense that is sometimes included within the crime of assault and battery. It refers to permanent injury inflicted on a victim with the intent to injure. And we may be talking about trying to disable or disfigure a person. So the way that mayhem works is if you are somebody who says, I'm going to show the snitch what happens to snitches, right? And you grab a baseball bat and you intentionally go after that person's kneecaps with the desire to break their kneecaps so that they can no longer walk. That would be an example of like mayhem. That would be an example of mayhem, because the reason that you use that baseball bat was to specifically harm the person at a specific body part, to help make them less able to fight or to help make them less able to move, right? You're trying to limit them and their ability to genuinely just live their life regularly. You're trying to, as the definition literally says, you are trying to, in many instances, or in general, permanently injure the person. So it's no longer, hey, I'm going to beat you up and just, hurt you really. No, it's, hey, we want you to become incapacitated, right? There's a permanency to the definition of mayhem that is not necessarily present with your typical batter. All right. So that's it for our assault and batteries. I want you to be familiar with simple assault, aggravated assault, simple battery, aggravated battery, regular assault, and mayhem. From there, we get to talking about a different crime against person, which is robbery. Okay. Now, robbery is defined by the FBI as one of the 4 serious violent crimes. The FBI categorizes violent crimes as being murder, rape, robbery, and aggravated assault. We're really talking about aggravated battery. So what is robbery? Right? A lot of times students confuse what robbery means because you guys associate with robbery with stealing. You think, oh, well, that person robbed me, therefore, what I'm really saying is that person stole something from me. Robbery is a little bit more complicated than that, right? Robbery is very unique because robbery is both a crime against the person and a crime against property. And the textbook defines robbery as the taking or attempting to take anything of value from the care, custody, or control of a person by force or threat of force or violence, or by putting the victim in fear. Okay. So what makes robbery a crime against the person is this usage of force or threatening of force that puts the victim in fear. Okay. So if we were to divide robbery into its 5 elements, the 5 elements of robbery are a trespassory taking, meaning a taking without giving permission, basically stealing. A carrying away, so first you take, then you carry away of the personal property of another with the intent to steal. Okay. But what I would make sure that we would reemphasize is that this trespassory taking, which is the first element, was done by force or intimidation. Okay. So that's really robbery, right? Robbery is when you take something from somebody else that has value by force or threat of force or violence, or by putting the victim into fear. That is robbery. And it is, again, both a crime against the person and a crime against property. You can really, if you really wanted to simplify it, stealing something from somebody's physical possession by using force or intimidation. That's really like the most simplified definition I can give you of robbery. Now, there is also, I'm not going to get into that, I don't care. So that's robbery. Let's define rape. Rape is very tricky to define. In fact, I can give 4 different definitions of rape easily off the top of my head, and I have done so before. But for the sake of keeping things simple, I'm only going to use the definition of rape that the textbook gives me. And I'm going to try to keep this simple because we could devote hours to discussing the correct definition of rape and really struggle with it. All right. So historically, the FBI has defined rape as the carnal knowledge of a female forcibly and against her will. That's a poor definition. That didn't finish it. I don't like this. I don't like any of this. All right, I'm going to give you my own definition. Rape is sexual intercourse without consent. Short, sweet, simple, to the point, right? Sexual intercourse without consent. Understand that in order for rape to take place, we're talking about sex. without somebody giving you permission. And it does get tricky as to how we define consent. That becomes challenging. Different people define this in very different ways, even though it should be even though it should be something that's straightforward, and that's part of what makes discussion on rape so challenging. I am going to post. I'm going to show you a video regarding consent, the concept of consent, which I think can help.
If you're still struggling with consent, just imagine instead of initiating sex, you're making them a cup of tea. You say, "Hey, would you like a cup of tea?" And they go, "Oh my God, I would love a cup of tea, thank you." Then you know they want a cup of tea. If you say, "Hey, would you like a cup of tea?" And they're like, I'm not really sure. Then you can make them a cup of tea or not, but be aware that they might not drink it. And if they don't drink it, then, and this is the important bit, don't make them drink it. Just because you made it doesn't mean you're entitled to watch them drink it. And if they say, "No, thank you," then don't make them tea at all. Just don't make them tea. Don't make them drink tea. Don't get annoyed at them for not wanting tea. They just don't want tea, okay? They might say, "Yes, please, that's kind of you." And then when the tea arrives, they actually don't want the tea at all. Sure, that's kind of annoying as you've gone to all the effort of making the tea, but they remain under no obligation to drink the tea. They did want tea, now they don't. Some people change their mind in the time it takes to boil the kettle, brew the tea, and add the milk. And it's okay for people to change their mind, and you are still not entitled to watch them drink it. And if they are unconscious, don't make them tea. Unconscious people don't want tea, and they can't answer the question, "Do you want tea?" because they're unconscious. Okay, maybe they were conscious when you asked them if they wanted tea, and they said yes, but in the time it took you to boil the kettle, brew the tea, and add the milk, they're now unconscious. You should just put the tea down, make sure the unconscious person is safe, and this is the important part again, don't make them drink the tea. They said yes then, sure, but unconscious people don't want tea. If someone said yes to tea, started drinking it, and then passed out before they finished it, don't keep on pouring it down their throat. Take the tea away. Make sure they are safe, because unconscious people don't want tea. Trust me on this. If someone said yes to tea around your house last Saturday, that doesn't mean they want you to make them tea all the time. They don't want you to come around to their place unexpectedly and make them tea and force them to drink it, going, "But you wanted tea last week," or to wake up to find you pouring tea down their throat, going, "But you wanted tea last night." If you can understand how completely ludicrous it is to force people to have tea when they don't want tea, and you are able to understand when people don't want tea, then how hard is it to understand when it comes to sex? Whether it's tea or sex, consent is everything. And on that note, I'm going to make myself a cup of tea.
Right, so this video was actually published by the British. I believe it was it was done by the British government to help people understand the concept of consent. A lot of things there sound like they're common sense, but unfortunately, sometimes common sense is not that common. The problem with teaching and discussing the concept of rape is that regrettably men and women approach it from different perspectives. So let's get a few concepts very quickly out of the way. First off, men can be the victims of rape. And that's something that many times students struggle to understand. Men can be victims of rape, and men can be raped by women. Okay. 1 out of 6 instances of sexual assault. Really, we're talking about sexual battery, right? Unwanted touching or harmful touching of another sexually. 1 out of 6 occur to men. Now, that's not the same thing as rape, because rape involves sexual intercourse. But that gives you an idea that men can be the victims and are the victims of rape. However, overwhelmingly, the victims of rape are women. That's just the reality of it. Now, typically, our legal system is designed in such a way where we like making sure that it's hard for the state to prosecute a defendant, right? We typically, sorry, there's been a mosquito out, so it's driving me crazy here. Can't kill it. We like to make it difficult for the state to be able to prosecute somebody. We want to make sure that if the state is able to convince a jury that a defendant is guilty of a crime, they've done so beyond a reasonable doubt. The problem, of course, is that with rape, it's much more challenging, right? Many times people switch their perspective when it comes to rape. The idea being that, well, we want to always believe the victim, the supposed victim. But from a constitutional standpoint, defendants always have legal rights. They have due process. And the state must be able, including with rape, to prove the crime of rape beyond a reasonable doubt. And so that becomes very challenging sometimes. Historically, that puts the victim in a position where many times the defense attorney from the supposed rapist puts the supposed victim in severe questioning bias, motive, whether they correctly remember. And there is nothing worse for somebody who has been the victim of rape to have to relive their experience, retell their experience, and not only that, go to trial, testify on the rape experience, and also testify in a way that basically what they're saying with a defense lawyer who many times is trying to say, you don't really remember, this didn't really happen to you, or it didn't happen the way you're describing it, especially if it did happen the way that the victim says it happened, right? So that becomes very challenging when discussing the topic of rape. Historically, there were 4 theories of rape. I'm going to go over them very quickly. The first one was, or actually not historically. Today we can discuss rape using 4 different theories. Historically, the first theory of rape for almost all of mankind's history was the definition of rape that most people subscribe to, which was the only way that it was rape was if the victim didn't physically fight back. The idea was that if you were being the victim of rape, and again, historically, people only saw women as being victims of rape, if you didn't physically try to fight back to protect your dignity, to protect your, in many instances, virginity, then you really wanted that sexual intercourse. And of course, that's extremely offensive and insulting, right? But that used to be the historical definition of rape. And when that definition of rape was around, the other concept that was also around was that a husband could never rape his wife. So the idea was that marital rape could not exist. Why not? Because back then, the viewing of, or the perspective regarding, and I say back then, really we're talking about around the 50s, 60s, 70s when this started to change. But before then, the perspective was that a husband could never rape his wife because a wife belonged to his husband, right? This was, in my opinion, a poor interpretation of the Bible. The idea was that once a wife and a husband became married, the husband was legally always required to financially provide for the wife. That was law legally. No longer is that the case today, thankfully. But because the husband was legally responsible for the wife financially, the husband had access to unlimited sex with his wife whenever he wanted it. And the wife could not say no because that was a responsibility, almost a requirement of the wife to do. Now, obviously, not good, right? This is horrible. All sorts of problems that arise from this. And luckily and thankfully, our laws have evolved and we no longer have that approach. But that was the first theory of rape. The idea, this was a concept that was related to the first theory of rape. To re-summarize the first theory of rape, it wasn't rape unless the woman physically, and I say woman because historically that was always the victim, the woman physically resisted. The second theory of rape is the modern, the most modern definition of rape. I should not say the most modern. It's the most commonly held definition of or theory of rape that people use today. It's the one that almost everybody's familiar with. It's the one that most people would use when trying to define rape, and that is the idea that in order for it to be rape, the victim has to show that they physically or verbally said no. Physically, they tried to physically fight back, but also if they simply tried verbally to say no, then that's enough, right? We can summarize the second theory of rape as no means no. That's what many of you have heard of. Now, under the second theory of rape, this is the most commonly held definition of rape even to this day. The state has to prove that the alleged victim did not, or rather, verbally or physically try to refuse the sexual intercourse. There is an exception made usually under this second theory of rape that would prevent the defendant from being able to say that the victim never said no because she was drunk or he was drunk. Okay. The idea being that if you're passed out, intoxicated, I shouldn't say drunk, the word I should say is passed out, unconscious, unable to express yourself, well, that doesn't mean that you agree to sex. So under the second theory, many times that exception is made where the failure to be able to say no does not give permission to the person initiating the sexual interaction from pursuing sex, from being able to have sex. Okay. That is the second theory of rape. The third theory of rape is one that some states like. Many women prefer this, again, because women are the more common victims of rape. Many men are uncomfortable with it. And the third theory of rape, the way it works is that it is rape unless the defendant can show that the alleged victim verbally or physically consented. So we now shift the perspective. Before, under the first and second theories of rape, it was always the responsibility of the state to prove that the alleged victim did not want to have sexual intercourse, either physically, if it's only first, or through physical means, if it was the first theory of rape, or by physical or verbal means, if it's the second theory of rape. Under this third theory of rape, we've now shifted the perspective to now require the defendant to show, right, that the alleged victim did verbally or physically consent. And if the defendant isn't able to show that, that becomes problematic. Of course, this is very tricky because the defendant doesn't typically have to prove anything in a defense criminal trial. So the state has to prove that the alleged victim didn't verbally or physically consent. There is a difference. Okay. And then the fourth theory of rape, which some people like, is terrifying for men. I would argue it's also terrifying potentially for women. Says that it's rape unless you are able to verbally receive consent. Now, the nice thing about the fourth theory of rape is that it eliminates any ambiguity, because sometimes people say, well, I thought the person wanted to have sex with me because they physically seemed interested in having sex. The concept of showing physical consent to sex can be tricky sometimes for some people, okay, particularly men. We eliminate that ambiguity under the fourth theory. The problem is that in order for it to not be rape, every time the person has sexual intercourse with somebody else, they have to say yes. They have to receive a verbal yes, meaning that many spouses who didn't verbally agree to having sex, but they started removing each other's clothes and getting into sexual intercourse will be guilty of mutually raping each other. And obviously that doesn't make sense. But that's the fourth theory of rape. All right. Now, trying to make sure that I covered that definition of rape. We talked about marital rape and how historically it wasn't a real crime, but nowadays marital rape is as much a rape crime as any other. The most typical type of rape or sexual assault takes place, or sexual battery, with acquaintances. We call that date rape or acquaintance rape. See, the biggest problem is that in the United States, we have been conditioned by family members, not just in the US, but everywhere. Women specifically, because remember, they're usually the victims, unfortunately. Society has taught people to believe that rape is going to occur by a creepy person that you've never met, that you don't know, that's out to try to hurt you. And while that does happen about 21% of the instances of rape, the vast majority of them, the plurality of them, I believe it's in the 40% range, takes place with somebody that you know is a friend of a friend, or you kind of know but are not super close friends with, or somebody you've been dating or been in a relationship with. We're talking about potentially, when you combine date rape, which is acquaintance rape, I kind of know the person, I don't know them that well. They're a friend of a friend, and you've met them a few times, and now at a party many times, the event happens. That's an example of acquaintance rape or date rape. Or rape that takes place by a person you knew very closely. That's about 70% of rape. So typically, the rapist is somebody you know, right? And that's one of the things that makes rape so challenging many times, is that society has taught, specifically women, to believe that rape is going to occur by somebody they don't know. And while that may happen, I don't want to dismiss the reality of that happening. The vast majority of rape instances take place with somebody you are either very close to, or have been potentially in a relationship where you have previously agreed to having sex, many times maybe even, or with somebody, whatever, that you've casually seen. Those are the most common instances of rape, right? The British video says it best. Just because you've been given permission to have tea in the past does not mean that on this particular instance somebody wants to give you tea. Same thing with sex. There is a very real problem with society, and I would say specifically with men, where men believe that, hey, I've had sex with this person 1,000 times in the past. I am entitled to having sex with them on the 1,001st time. Big problem, big mistake. And not just the word mistake doesn't do it justice. Big, big problem. No, absolutely not. Not true. I can want to have a Big Mac 1,000 times, and then on the 1,001st time I drive near McDonald's and say I'm not in the mood for a Big Mac. And that doesn't give McDonald's the right to try to force me to buy a Big Mac, right? Same logic applies with sex. Statutory rape, I want to cover it too. It is something that the textbook mentions. It is another crime. Statutory rape is sexual intercourse with somebody under the age of consent. Age of consent is simply the age that every state and country defines as being the age where a human being is mentally capable, mentally competent to be able to agree to having sexual interactions with an adult. Okay. Notice I said the word adult. A 14-year-old can have sex with a 14-year-old, and neither one of them is guilty of statutory rape. However, if a 50-year-old has sex with a 14-year-old in any state in the United States, that's a crime. We call that statutory rape. Regardless of whether the 14-year-old agreed, the 14-year-old may have agreed to having sex. We call it statutory rape because consent is no longer a question. We don't care about the issue of consent. the mere fact that that person has not reached legally what has been defined as the age of consent, the age at the point at which a human being can agree to having sex with an adult, means that statutory rape exists regardless. Okay. Now, statutory rape is a real problem because even in a state like Florida, right, the age of consent in Florida is 18, meaning that only an 18-year-old may have sex with any other adult of any other age. Well, this becomes a problem many times because what happens with let's say a 15-year-old female who has a fake ID, goes to a club that's 18 and over, and starts hitting on a 25-year-old or starts flirting with a 25-year-old guy, right? And the 25-year-old guy, trying to be cautious, asks the female her age. She says she's 18 or 19. The 25-year-old is paranoid and asks for a driver's license, and the 15-year-old pulls out uh, a fake ID that shows that age. And the 25-year-old then proceeds to having sex with a 15-year-old. Guess what? The 25-year-old is still going to be charged and is guilty of statutory rape under present Florida law. Florida law does not excuse that mistake. Now, if you're a guy, that's terrifying. It's unfair for guys. I mean, most men find that unfair, but the truth is, you gotta be careful. That's what the law says. You've got to be very cautious, very careful. If you're in doubt, don't do it. That's the best thing I can say. Now, the age of consent is a very interesting topic. I'm going to show you some facts, some information on it. Let me share screen again. Right. And so these are the ages of consent in the United States. Now, if you look at this map, you'll see that light green color means that 18 years old is the age of consent, right? So New York, Vermont, Delaware, West Virginia, Tennessee, Arkansas, Iowa, Florida, Utah, California, and Oregon. 18 is the age at which point any person, at which point that person may have sex with anybody else. And the other person has no legal punishment. So an 18-year-old in any state in the United States may have sex with a 50-year-old, a 60-year-old. That's not the most common age of consent in the United States. Right across the border in Alabama and Georgia, the age of consent is 16. Okay. And if you notice, most of the states in the US, the age of consent is 16, meaning that at 16, the 16-year-old has the legal, according to these states, the legal capacity to engage in sexual relationships with anybody else from any age. That's an adult. Some states have 17. You're looking at them in that olive green. Now, some of you have problems with that age. Some of these ages of consent. Some of you strongly believe that it should be 18. I've seen that happen. I'm going to show you Europe and the rest of the world. Okay, so this is the rest of the world. If you notice, here's South America, right? Brazil, 14. Bolivia, 14. Paraguay, 14. Peru, 14. Ecuador, 14. Colombia, 14. Argentina, 18. And Chile, 18. I always find it fascinating when countries are so close to each other and like you see that huge discrepancy in years, 14, and then you go to 18. Uruguay, 15. Venezuela, 16. Suriname, 16. You notice that 14 is very common, 15, 16 in different parts of South America. And if you were to actually look more closely at Europe, France, 15, Spain 16, Ireland 17, UK 16, Iceland 15, Germany 14, Italy 14. The most common ages are 14, 15, and 16 within Europe. Why? Well, I need to remind you guys something, right? Historically, people married at a much younger age. People used to have sexual relations at a much younger age, so they were married at a much younger age. And historically, people waited until marriage to have sex. And people died a lot younger back then, right? So the age of consent in many countries around the world reflects the historical reality that life expectancy isn't what it is today, or wasn't what it is today, and that people were expected by society to start a family at a much younger age. Uh, some of those realities are not there necessarily today, right? Like life expectancy across Europe, uh, the United States, even most of the world has dramatically increased. But not all states agree on what the correct age of consent is. Not every country, I should clarify, agrees on what the correct age of consent is. And of course, these red countries, right? You can see the map here, say that you have to be married to having sex. So if you're not married, then it's a crime of adultery for those countries, and it's a crime. And Japan, it's very interesting. The country, the age of consent is 13. I believe that the individual regions within Japan have different laws where they push the age of consent up. But the country of Japan, the age of consent is 13. China, 14. North Korea, 15. South Korea, 20. Again, one of those things that I find super interesting. The two Koreas are very largely divided on what the correct age of consent should be. Uh, the youngest, for those that wonder, is there is a country where the age of consent is 11, and that's Nigeria. Uh, Weird. Niger, 13. You know, there are a couple where the age of consent is 12, the Philippines, Angola, and 13, Comoros, Japan, Niger, uh, the I can't pronounce that. Sahrawi Arab Democratic Republic. All of them are, and Burkina Faso. All of them have 13 as the age of consent. So again, the point of that is to show you the different concepts and the different ways the world views statutory rape, sexual intercourse with somebody under the age of consent, an adult having sexual intercourse with somebody under the age of consent. The age of consent is the age at which society believes that you have the mental capacity to agree to having sex with an adult, and it varies from state to state in the United States and from country to country across the world. Some states have what are known as close in age exceptions. Florida has them. So if you are in Florida, a 16-year-old or a 17-year-old may have sexual relations with an adult up to the age of 23. So 23 with 16 is allowed, 22 with 16 is allowed, 21 with 16 is allowed, 20 with 16 is allowed, 19 with 16 is allowed, 18 with 16 is allowed. 24 with 16 or 17 is not allowed. Okay. And then, so that's Florida. There's a close in age exception where a 16-year-old, where up to a 23-year-old may have sexual relations with a 16-year-old. And then also, there's the concept of Romeo and Juliet laws. Romeo and Juliet laws, what they do is they don't eliminate the fact that it's statutory rape. But in Florida, for example, if you are a 19-year-old or an 18-year-old, and you have sex with a 15-year-old, or if you are an 18-year-old and you have sex with a 14-year-old, after you serve your punishment for statutory rape, you can request a judge to remove you from the sex offenders list so that you don't become permanently labeled as a sex offender. So you don't become permanently labeled as a pedophile. All right. So those are Romeo and Juliet laws. They don't eliminate, again, whether statutory rape occurred, but they do eliminate the, or they give you a route to being removed from sex offenders list once you've served your punishment. That is everything that I wanted to cover regarding rape. Let's move on to another crime against the person. It's a long chapter. Kidnapping. All right. Kidnapping is defined as restricting the freedom of a victim against their will. Historically, it also required moving the victim from one place to another. False imprisonment was basically the unlawful and knowing restraint of a person against their wishes to deny them freedom. So, some people separate the definition of false imprisonment from kidnapping. False imprisonment is when you basically place a person, when you restrict their freedom, that's false imprisonment. When you place somebody and you say you can't leave this area and you may no longer move in this area and you deny them their freedom, that's false imprisonment. Kidnapping is when you do this after having moved the person or the victim from one place and taking them to another location. To give you more precise definitions, just because I like doing that, kidnapping is restricting the freedom of a victim against their will and removing the victim from one place to another. Some states don't require the removal of the victim from one place to another. False imprisonment, on the other hand, is the unlawful and knowing restraint of a person against his or her wishes so as to deny freedom. A lot of people combine these terms and say false imprisonment is the same thing as kidnapping. I'll do that. So I'll say that false imprisonment and kidnapping are similar or the same for our class purposes. Even though kidnapping could be defined a little bit differently as it requires in many states this additional element of moving the person initially from one place to another, and in that moving them, they are now being denied their freedom, as opposed to the person arrived at a specific place on their own, and after they arrived at that specific place on their own, they were denied their freedom to move and leave. All right. Stalking. Stalking is becoming a much bigger issue in the United States. The textbook defines stalking as a course of conduct directed at a specific person that involves repeated visual or physical proximity, non-consensual communication, or verbal, written, or implied threats, or a combination thereof, that would cause a reasonable person fear. The term repeated means 2 or more times. Now, different people define stalking differently. Different states rather define stalking differently. They may change the wording a little bit. Here are some examples of stalking. It is reported that an estimated 3.3 million people aged 18 and up were subjected to one or more of these acts during a 12-month period, meaning stalking is much more prevalent, much more common than we realize. So these were some of the examples of stalking. Making unwanted phone calls, sending unsolicited or unwanted letters or emails, following or spying on the victim, showing up at places without a legitimate reason, waiting at places for the victim, leaving unwanted items, presents, or flowers, posting information or spreading rumors about the victim on the internet in a public place or by word of mouth. All right. Cyber stalking is new. It's another type of stalking. Many states, or some states, still don't have a law in the books for it, but it's pretty much common at this point that every state has one. And it's really simply defined as electronic stalking. Okay. Electronic stalker. And that's another crime against the person. Okay. Last but not least, bullying, right? There's the last crime against the person that we're going to discuss. And after this, we're done with the chapter. Bullying is the repeated use by one or more students. So notice we're talking about students. Of a written, verbal, or electronic expression, or a physical act or gesture, or a combination of both, that is directed to a victim and causes the victim physical, either 1, physical or emotional harm or damage to their property, 2, places the victim in reasonable fear of harm to himself or of damage to his property, 3, creates a hostile environment at a school for the victim, 4, infringes on the rights of the victim at school, or 5, materially and substantially disrupts the education process or the orderly operation of a school. Yeah. Okay. It's a massive definition for bullying. What I want you to take away from bullying is, number 1, bullying is a repeated act. One instance of somebody making fun of you in a way that really hurt your feelings in school does not make it bullying. It's got to be a repeated act. Secondly, it's done by students. So it's not a teacher who does it to you, and it's not somebody, I can't get bullied because I am not a student. So it's got to be between students. And more specifically, we're really talking about elementary, middle, or high school students. I guess pre-K students too. Okay. So this is a crime it's a crime, notice what I said, a crime that occurs at the child level, not really at an adult level. And there are different ways that bullying can be expressed or manifested, but the general gist of it is that it interrupts with the ability of the student to learn, where it places the student at fear for their life or for their own property, or they are physically or emotionally harmed by the actions of the bully. Okay, that's really like the gist of bullying. Okay, and it can include nowadays cyberbullying. So bullying can also be done through social media. In fact, I would argue some of you might be victims of bullying, some students. All right. And that's pretty much it with this chapter. Let me know if anybody has questions. If not, see you guys next week. Bye, everybody. Stay safe.